Yes.
A very good evening to one and all. I, Pragya Parijat Singh, Member Executive SCAORA, welcome you all to SCAORA Lecture Series 2025. Today's lecture is the fourth in series and on the topic Practice and Procedure. I, on behalf of entire Executive Committee of SCAORA, welcome Senior Advocate Gagan Gupta sir to deliver today's important lecture. I'd like to give a brief introduction of our esteemed guest before we start with the session today. Sir is a senior advocate at Honorable Supreme Court of India. Sir has completed his BA Honours from Political Science from Venkateshwara College and LLB from Campus Law Center, University of Delhi. It has been 25 years of practice for Sir, and he started it in the year 2000. Sir became an advocate on record in the year 2006-2007 and was also rank 2 holder in the AOR examination held in June of 2006. Sir was designated as a senior advocate by Honorable Supreme Court of India via its notification dated 19th January 2024. Sir conducts matters across all the courts of India and not just confined to Delhi. He has a specialization in matters pertaining to national consumer disputes, FEMA, PMLA, SIFMA, NDPS, and has been a part of Katina of important landmark judgments pertaining to land acquisition, NDPS, Religious Societies Act, insolvency and bankruptcy, child custody, service lot, and whatnot. We are extremely humbled and happy to have you here, sir. Over to you. We are going to hear it directly from the horse's mouth. Thank you.
Thank you, Pragya, for a wonderful introduction. Just that today is not practice and procedure. That was on Sunday. So today we have 3 judgments from the leading cases.
3 judgments. Yes, I just noticed that. Extremely sorry.
That was one cut and copy and paste which was required. Anyway, that is in the lighter vein. Now, just getting on to the lecture. So today I have been allocated 3 judgments, friends. One is the Indore development. One is GNCT versus BSK. And the other is the 9 judges Constitution Bench and Property Owners Association. So a prelude to my lecture is that this is an open book exam. So this exam, what it does is that it teaches you how to quickly read lengthy judgments, how to call out their ratio decidendi, how to pull out what is obiter dicta, and so on and so forth. So this is not an exam only for your AOR shape, but also to teach you how to quickly read the judgments and make sense out of it. So you must read all the judgments in your syllabus with this objective in mind. It will always help you in this career. Now we get on to our first judgment, which is 2020 Volume 8 SCC 129 Indore Development Authority versus Manohar Lal and others. It's a Constitution Bench judgment. Now this judgment has raised and answered a large number of questions, not only pertaining to the Right to Fair Compensation Act, the 2013 Act, but also to land acquisition in general. So the 2013 Act was enforced with effect from 1/1/2014, and it replaced the 1894 Land Acquisition Act. This 2013 Act is a comprehensive legislation and is reflective of the progress made by our country. It is a welcome legislation after the earlier Act held the field for about 120 years. So this 2013 Act has modernized the concept of not only land acquisition, but also the allied concepts of rehabilitation and resettlement of the land. So earlier there was no statutory regime governing rehabilitation and resettlement. It was by way of schemes by the respective state governments. But now we have a statutory recognition to the same. This act has also come as a welfare move with respect to computation of compensation, which is to be paid to the land users in case their land is acquired. Because now the compensation payable is at par with the realistic market value instead of the conservative methods provided under the old act. So the first set of cases concerning the 2013 Act reached the Supreme Court of India within 23 days of the Act coming into force, and it involved interpretation of the famous Section 24(2) of the 2013 Act. This judgment, as you all know, is reported as Pune Municipal Corporation versus Misrimal Solanki. You can note down the citation 2014 3 SCC 183. Today I will be a little slow on citation. I was told earlier that citations in the Sunday lecture were very fast. So this is a judgment dated 24 January 2014. Now this judgment came when the act had just come into enforcement, like I said few minutes back. It is a judgment by 3 honorable judges. Of course, this judgment now stands recalled. I'll give you the history how it has happened. It gave a purely textual interpretation to the provisions of section 24(2), which says that notwithstanding 24(1), in acquisition proceedings which were initiated under the old Act, 1894 Act, where an award was made 5 years or more prior to 1/1/14, which is the date of enforcement of the new Act, and one of the two conditions is satisfied. So this is the basic of Pune and then Indore. Pune says one of the two conditions was to be satisfied. Either the physical possession has not been taken or compensation has not been paid. If one of these conditions is satisfied, the court said that the acquisition proceedings shall be deemed to have lapsed. The government, of course, as you all know, had always the power to reacquire the land under the 2013 Act if the land was still relevant to be acquired for the given purpose. There is a proviso to section 24(2) that was also interpreted by the Supreme Court in Pune Municipal to the benefit of the landowners. Now, insofar as the expressions compensation has not been paid, the Pune Municipal judgment referred to section 31 of the 1894 Act, which enjoins upon the collector to tender compensation to the landowners, or in case of landowners not consenting to take the compensation for the required land, or if there is a title dispute or a dispute as to apportionment of compensation among different landowners, then the collector had to deposit the compensation in the court. Court meant the court which will hear the reference under section 18, which was the learned additional district judge of the area. Similarly, the word paid, the court said in Pune, has not to be equated with the words offered or tendered. So paid means actual payment and not only tender. It was held that the 1894 Act, being an expropriatory legislation, had to be strictly followed. And accordingly, in the facts of that case, it was found that the compensation had not been paid or deposited in court, and thus the land acquisition proceedings were deemed to have lapsed. Now, this judgment came as a wave of happiness and relief for large number of landowners across the length and breadth of our country. The intent of the legislation was clear, that the government, if it had not paid the compensation for 5 years or had not taken physical possession, then the acquisition would be treated as stale. Because in today's world, if 5 years nothing is happening, it means that the government did not really require this land for the relevant purpose, and it would become meaningless, and the land should revert back to the owners. And of course, as I said, the government would have the liberty to reacquire the land under the 2013 Act, which provides a very strict regime of rehabilitation, resettlement, and of course, compensation as per current market norms. Now, after this judgment in Pune Municipal regarding section 24(2), there were several thousands of judgments which were passed by different high courts across the country and also by the Honorable Supreme Court following Pune, and lands were released one after the other because there were several instances where the government was sitting tight on the matter, either not taking physical possession or not depositing compensation as interpreted by Pune. Then after a few years, what happened was that the court probably realized that this interpretation which is given to 24(2) by Pune is perhaps incorrect. So then comes a judgment of 3 honorable judges, which is not in your syllabus, but you may make a note. This is Indore Development Authority versus Shailendra. This is 2018, 3 SCC 412. This 3-judge bench judgment, although it was a 2:1, the late Justice Shantana Gaudar held that the Pune is not per incuriam, but the 2 other judges held that Pune seems to be per incuriam. So the judgment of Pune Municipal was referred to a larger bench, which was a 5-judges bench, which framed several questions falling for consideration of the Constitution bench. Now, in the Sunday lecture, I had said that there was another judgment in Indore, which was a recusal judgment. So that you may either go back to the lecture. We had circulated the note also, although not important for today's lecture. But anyway, you should know that the same honorable bench which referred Pune Municipal to a larger bench, one of the honorable judges was part of the Constitution bench also, who was hearing the reference. So the issue arose whether he should be part of the bench. So they first gave a judgment on recusal and said that he's not bound to recuse. So be that as it may, the Constitution bench, which is now today for discussion, is Indore Development versus Manohar Lal. Now it gave a completely diametrical interpretation to 24(2) than given by Pune. So I'll just briefly explain 2 reasons, because we have seen, at least in the 2 question papers, in the last few years after this judgment has been rendered in 2020, there were very simple questions about this judgment. One, in fact, was a yes or no question, like a multiple choice, as to whether if acquisition would lapse if two conditions are met or one condition is met. And in one of the previous years, the question was that please give us situations where the land would be deemed to be lapsed, the acquisition would be deemed to be lapsed under 24(2). And then there was another sub question to that which said that also give instances where the land would not be treated to be lapsed by the court under 24(2). So this is a fairly simple judgment, but you should know because there are several other aspects here which can be asked by the examiner. So this judgment, I would say, has become a kind of a treatise on various aspects of land acquisition, not just the 2013 Act, but several aspects in general. So the first and primary question on which the entire fabric of Section 24(2) depends was the interpretation of the word or, which was occurring between the expressions physical possession has not been taken and compensation has not been paid. So the Constitution bench, if I can just conclude before I explain, interpreted that or has to be read as and. So if Pune Municipal said that for 5 years prior to 1114, if compensation has not been paid or possession has not been taken, then the land is deemed to have, the acquisition is deemed to have lapsed. Indore said, no, this or you have to read as and. Both conditions have to be fulfilled. And the two conditions have also been explained in detail so that there is no route out for the landowners. Now, the Constitution bench thus discusses in detail the principles of interpretation as to why this or has to be read as and. And the test applied was that since both the conditions prior to the or and subsequent to the or are negative conditions, therefore, as per certain judgments cited in this judgment, you have to read this or as and. And it was held that if both conditions are satisfied, then of course land acquisition proceedings would lapse, otherwise no. Now the court, while giving this reasoning, considered that under the 1894 Act, if the award stood passed under Section 11 and possession used to be taken over by the collector after Section 11, Section 16 provided that land would vest upon the government absolutely, even prior to payment of compensation. So the court held that vesting under Section 16 of the old Act in the government of the land loser's land after acquisition did not depend upon payment of compensation. And even if payment was not tendered or deposited in court under Section 31 of the old Act, the only consequence was for the government to pay interest, which was about 9% for the first year and 15% thereafter for the default period. So it held that under the old Act, non-payment of compensation did not affect the vesting of the land in the government. So please try and appreciate the court was wanting to reach to a conclusion that only because possession was not taken or compensation was not paid, therefore under the new Act, you cannot say that it has lapsed. So it took inspiration from the old Act, 1894 Act, saying that non-payment of compensation there did not affect the vesting of the land and it would not revert the land to the landowners. Now, the Constitution bench then goes on to hold by looking at the legislative history and the objectives of the 2013 Act and also took the aid of the proviso. Now, there is a proviso to Section 24(2). So if all of you have this Act, the right to fair compensation, you will see the placement of the proviso. The proviso is after 24(2). The landowners, obviously, because it suited them, they sought to argue that this proviso is actually a proviso to Section 24, subsection 1, and not to Section 24, subsection 2. Now, at the cost of reiteration, I need to emphasize that the Indore judgment, of course, holds what it holds, but you also have to read it for trying to understand the different principles of statutory interpretation by divorcing it from the actual subject matter of Indore development, because there can be questions saying that what is the tool of interpretation to read or as and. Even commas, full stops, and semicolons have been interpreted, as I would just clarify to you in the later part of my lecture. So the landowners, like I said, argued that the proviso cannot be treated as exemption from lapse, but it has to be treated as a proviso to Section 24(1)(b), otherwise there will be anomalies. But the Constitution bench in Indore rejected this submission, and it said that the proviso, as per its location, is given in the statute after Section 24(2). So even if it does not make any sense with 24.2, we will not read it as part of 24.1. We will rather use it as a tool, as an aid for interpretation of 24.2, which is that or is to be read as and. So that was their interpretation of the proviso. Now, after they hold that for lapsing under 24.2, lapsing would mean the land reverts to the landowners. The court embarked on the journey of interpreting the two conditions also, which is whether physical possession has been taken or not, and if yes, how it is to be taken, and what amounts to payment of compensation. So the court wanted to make it as strict as possible, that even if both conditions are satisfied, what is it that you have to see? So first we'll discuss payment of compensation. So the court relied upon the 1894 Act, because as you would appreciate, before 1114, it was the 1894 Act which was applicable. So if the test of 24.2 is to be applied, we have to see whether compensation was paid under that act or not, and not under the new act. So section 31 and its subsequent and allied provisions of the 1894 Act were considered. And it was held that if the amount of compensation is tendered to the landowners. Now, this was the distinction between Pune and Indore, because the examiner can ask you a question in any form. He may say that what is the difference between Pune and Indore when it comes to payment of compensation? So what is important to understand is that Pune said that paid means paid. You have to go to his house and pay him, or you have to put it in his account. But Indore says that no, the government is obliged only to tender it to the landowners, and the obligation is discharged. Now, if the landowner refuses to take it upon tender, the next obligation in 31.2, section 31, subsection 2 of the 1894 Act is that the government has to deposit in the court. Now, why that deposit used to be in the court was that the court would further deposit that amount in a fixed deposit. So if you would see, when we deposit some amount in the Supreme Court, it goes to the UCO Bank and they make an FDR out of it and send it back to the registry, so that the amount doesn't remain idle, it earns interest. Similarly, the government had to deposit compensation in the court. The only purpose was court would invest it in a fixed deposit. So if the government is unable to deposit in the court and keeps the money in its treasury, which will not earn interest, the only consequence, said the Indore judgment, is not lapsing. The consequence is that the landowners will be entitled to interest on the same, like I said, 9% in the first year, 15% subsequently of the default. Now, there was another section which is 55 of the 1894 Act. It takes the aid of Article 283 of the Constitution of India. It is regarding deposit of compensation, because in some states there were standing orders. There was a standing order in Delhi also, which says that in land acquisition matters, it is all right for the government to keep the money in its treasury, deposit the money in its treasury instead of the court. So after Pune, there were few judgments which said that no, such standing order is in conflict with the Land Acquisition Act, because the Land Acquisition Act says that you have to deposit in court. So the deposit by the government in its own treasury will not amount to deposit in court under 31. But since this Indore judgment had to overrule eventually Pune, so all the judgments which were a fallout of Pune and following the same line of reasoning for different aspects were overruled by the Constitution bench. So this is about payment of compensation. The first expression before the or, which is to be read as and. Now comes the later expression, which is the physical possession aspect. Now there are judgments of the Supreme Court prior to Indore, which say that as to how the government is to take physical possession. There are few judgments which said that mere drawing of a panchnama, which is a memorandum of taking possession after acquisition, is not enough. The government must ensure that the landowner is evicted from the land and that physical possession is taken by the government. So the Indore judgment did not like this concept. It says that there is a difference between the words possession in section 16 of the old act. The 1894 Act says that if the government takes possession, the land vests in section 16, vests in the government. But the provision of 24.2 uses the expression physical possession. So the court said that you don't have to read too much in this changed expression of physical possession, because of course the landowners argued that mere drawing of panchnama is not enough. After acquisition, they have to come and take actual possession. They have not taken because we have been in possession, we have cultivated, or we are living in it, or we are tethering our cattle, etc., etc. So the court had nothing doing. If there is a memorandum of possession showing that possession has been taken after acquisition, that will amount to taking physical possession of the land. So the reason was that whenever agricultural land is acquired, it is huge chunk of properties, and the government is not supposed to put a person physically or some police force in possession or to start cultivating the land unless it is used for the purpose of acquisition. So it says that once the memorandum of possession is drawn up, the landowner shall be deemed to be in unauthorized possession if he is later found to be in possession, because that will be treated as a re-entry and he will be a trespasser. So the entire concept of possession is discussed in this judgment, not only with respect to land acquisition, but if you go through it, you will find that even for general civil law, it has discussed the concept of possession, which is one of the oldest concepts of our jurisprudence. So you must go through this judgment with that prism also in your mind. So then the court discussed the concept of vesting in section 16 and 17 of the old act and held that drawing of panchnamas is the conclusive mode by the government to take possession. Now, these were the two hands, the right hand and the left hand of interpretation of section 24.2. So I've explained to you that the or is to be read as and. Physical possession means drawing of panchnama, which is usually done in an acquisition, and payment of compensation means that the compensation has been deposited in the treasury of the government. That is enough. So the doors were kind of shut for the landowners. Now, apart from that, there was another issue for which this judgment becomes irrelevant. It's a bit of a mathematical issue. The issue was that when we read 24.2, suppose both conditions are to be satisfied, suppose Indore judgment also applies to a given case, how to calculate 5 years period given in 24.2, which means that on 1/1/14, 5 years prior thereto, the award should have been passed and both these conditions are satisfied. So there used to be a dispute that suppose there was an acquisition in say 1990 under the old act, and somebody went to the High Court to challenge the Section 4 notification or the Section 6 declaration. And at times the Honorable High Courts or maybe the Honorable Supreme Court in an SLP or an appeal would stay the acquisition or would stay dispossession or give some kind of an interim order. So there was a judgment after Pune, because like I said, every bench was trying to follow Pune as constructively and specifically as possible. So there was this judgment called Sri Balaji Nagar Residential Association. That judgment said that as per the language of 24.2, even if there was an interim order by any court, the government is not entitled to include it in the period of 5 years, which means that 5 years period, if it has elapsed before 1/1/14, despite existence of an interim order, the land losers will get the benefit of lapsing. However, even before this constitution bench in Indore, which we are discussing today, this Balaji Nagar was actually overruled by a 3 judges bench in Indore versus Shalendra. I've given the citation earlier, 2018 3 SCC 412, because this was the judgment which started with referring the Indore judgment. So it specifically overruled Balaji by the 3 judges judgment itself by relying upon section 11A of the earlier act. So if you see section 11A of the 1894 act, that also had kind of a deeming provision with respect to limitation for passing an award by the collector under the old act. So section 11 and 11A were relevant. And there it said that if the collector does not pass an award in 2 years, then the acquisition would deem to lapse. However, there was an explanation which specifically provided that if in this period there was a court stay, then that period was to be excluded. So the court said that only because section 24.2 does not specifically say so. So although we cannot supply a casus omissus, which means that even if it's an omission by the legislature, and court, as you know, is not competent to provide that casus omissus if there is an omission. However, the court said that this is a case where the said omission is being misused by the land losers. So to avoid misuse, the court said that we can always invoke 142 and of the Constitution and hold that if there was an interim order prior to 1/1/14 with respect to any acquisition, then you have to necessarily see whether that 5-year period was before the interim order or not. So please appreciate now there were 3 fetters. One was physical possession, one was compensation paid, and the third one became the interim order. In one or the other case, there would always be an interim order with respect to acquisition. So therefore, the landowners were kind of prevented by all means from taking this plea of section 24.2 for lapsing. The court also said that actus curiae neminem gravabit, which means that act of court can do no wrong to any party. So if there was a stay by a court, then the government should not suffer because of the stay. Another important aspect which incidentally is mentioned in Indore, and you must read it, is the principle of restitution. What is restitution? The restitution is, you will find some earlier judgments like Southeastern Coalfields, etc. Many of us take a stay in our matters every day. But what perhaps you don't know is that tomorrow, if the other side wins the matter, I take a stay today, after 5 years in the High Court or in the trial court or in the Honorable Supreme Court, the other side eventually wins it. So then the court recognizes that the other side was wrongfully under an interim order, although it was a court order. But this interim order should not have been passed because the party opposite has won eventually. So there is this principle of restitution where the other side, if it wants, can sue for damages for that interim order taken by the petitioner against the respondent if the respondent eventually wins it. So for that purpose also, you should read this principle of restitution, which the court used as an aid or a tool to interpret that if there is a stay, we will have to exclude it from the 5 years period. Court also took cognizance of the fact that because of this 24(2) and its interpretation by Pune, some old and stale acquisitions were sought to be reopened. In fact, that was happening. Even I have done some cases where the acquisitions were of the year 1960, etc. There was also a very interesting case called Mahavir Singh. He came and alleged in the High Court that my land was part of the Raisina Hills, the president's estate in Delhi, and that there is no compensation, physical possession not taken, etc., that the land should be released and the acquisition should be deemed to lapse. So the court said that such incidents are on the rise and we must nip them in the bud. The 24(2) cannot be used to invalidate acquisitions which have stood the test of time and have concluded. So therefore, this was about the lapsing provision. The court also referred to Section 101 of the Act. For the sake of completeness, I am saying this. There used to be a Section 48 in the old Act. The government can itself, on factors which are provided in Section 48, used to release land despite award having been passed. So similar power is in Section 101 also. But court said that this power does not mean that we will use it to interpret 24(2) for the benefit of the landowners. Now, this was about Indore judgment. I can go on and on about that judgment, but we have paucity of time. The second judgment which is given to me today is 2024 7 SCC 370 GNCT versus BSK Realtors LLP and another. Now, this is a 3 judges decision bench of the Supreme Court. And this is perhaps rendered after the last year's exam. So you can expect a question from this. Indore, already 2 years there have been questions, but I don't know. But this GNCT BSK is recent, although it is in a way falling back upon Indore. Now here the question was, since you've understood in the first judgments lecture, which I've just given, that there was a dichotomy between Pune and Indore. Now in the meantime, what happened was that several SLPs, because the high courts were deciding in favor of the land losers, basis Pune. Several SLPs were filed by different statutory authorities, and many of those SLPs got dismissed either on the first day or after notice, etc., because Pune was holding the field. So please keep in mind, whenever there is an acquisition by the state, normally there would be 2 bodies. One would be the acquiring body. So for example, in Delhi, because only state has the power to acquire, corporation under a statute may not have the power to acquire. So the state is the acquiring authority, but state acquires it for the benefit of some authority. So like in Delhi, GNCT would acquire, and it would acquire either for a project of DDA or for any project of NCT, etc. So then 2 statutory authorities come into picture. So what used to happen was that after a High Court judgment basis Pune, in which the acquisition would be deemed to have lapsed, say GNCT came to the Supreme Court, their SLP was dismissed. DDA never came. But after Indore, everybody woke up from slumber and the other authority filed SLP saying that GNCT's SLP was dismissed or DDA's SLP was dismissed, but my SLP was not dismissed. So similar was a case in GNCT versus BSK, which is up for discussion. So the Honorable High Court there also had allowed the writ petition relying on Pune Municipal. The beneficiary, which is DDA, first came to the Supreme Court, and after grant of leave by the bench of 2 honorable judges, the Supreme Court dismissed DDA's SLP, which became appeal after grant of leave. Although DDA was given a year to still see if it can reacquire the land under the 2013 Act, but DDA never did so. So this marked the culmination of the first round of litigation. After Indore after Indore came into picture, now the government of NCT, which was the acquiring authority and not the beneficiary, approached the Supreme Court. Notice was issued. There were some observations in Indore that old matters can be reopened, etc. The landowners, as now respondents, they submitted that the doctrine of merger should apply. And since appeal at the instance of DDA against the same impugned order of the High Court, so it remains the same impugned order, same parties, the landowner is the same, just that the authority who is challenging the High Court order now becomes different. So therefore, this GNCT's SLP should also be dismissed. And only because law was changed by Indore, the CB judgment subsequently, that should not invalidate the earlier order of the Supreme Court in DDA's SLP. Now, this was again perhaps a vexed question for the Supreme Court. To the credit of the bench, it divided the matter into several categories for ease of reference and decision. And it's a short judgment. So my lecture is also going to be short on this. The court's analysis was one, res judicata. So it discusses some case law on res judicata. And it says, yes, ideally, if one authority's SLP is dismissed, then it stands to reason that the other authority's SLP should also be dismissed. However, both authorities do not have a conflicting interest here, inter se between them. Then secondly, the court said that we will have to invoke the public interest principle in land acquisition cases. Res judicata is a technical, legal, procedural principle. It operates to prevent the same parties from re-agitating the same issues. However, it said that the previous decision of this court in the first round, in this particular case, in the peculiar features of this case, would not operate as res judicata, because this rule does not apply hard and fast in situations where larger public interest is at stake. So acquisition, they said, is a larger public interest because the land is acquired for some public project, etc. Court said that we will have to adopt a more flexible approach, and because the matter is not a kind of an individual private dispute, but has far-reaching public interest implications. Now, the second issue after res judicata was merger. So the court said that in the light of settled propositions on the doctrine of merger and the rule of stare decisis, it concurs with the judgment Kunaiya Mat. I had referred to Kunaiya Mat on Sunday also. The merger, of course, all of you know, the High Court judgment, does it merge with the Supreme Court judgment if the Supreme Court judgment or rather order only says SLP dismissed, etc. So all of that is discussed with Kunaiya Mat. The court said that we agree with Kunaiya Mat. We also agree that doctrine of merger is not of universal application. The nature of jurisdiction exercised by the superior forum and the context or subject matter of challenge, which could have been laid, shall also have to be kept in consideration. And it said that the exception will only be permissible to this rule in the rarest of rare cases, very sparingly. Now, this judgment notices that the Pune Municipal judgment was finally recalled when the authority in that case filed an application for recall in Pune after the judgment in Indore. So, friends, court in BSK, this 3 judges judgment was conscious that an SLP by one authority was no doubt dismissed, and that too not by a short order, but by granting leave and maybe by a detailed order noticing Pune, etc. Still, the court said that what it will have to do is that it will lead to several anomalous situations. One anomalous situation could be what, that the one parcel of the land, suppose stands acquired, suppose there were 100 land losers whose land was taken in one acquisition. Some of them may have come pursuant to Pune, some may not have come. So it said that the anomaly would be one parcel of land stands acquired, vested in the state, free from all encumbrances, where maybe the neighbor's land, the adjoining land, stands released because of acquisition having lapsed under 24(2), because there were cases where the authorities could not locate all the records and were not able to come to Supreme Court. Now, it said that it is also possible that the parcel of land to which the acquisition is deemed to have lapsed already stands utilized for development of public infrastructure by the state authorities itself. And on the other hand, the parcel of land which vested in the state, maybe it is lying unutilized as the public project is yet to be completed. So by applying the doctrine of public interest, the court felt that it was necessary for the court to apply the not apply to the doctrine of merger mechanically for such kind of cases. And then the conclusion was that although the court was conscious that there were cases where even lapsing would happen even by the twin test given by Indore. Still, court said that we cannot close our eyes, and court gave some consequential directions which would help the landowners get the maximum compensation under the 2013 Act. But court said that we will not allow the land to revert to the landowners. So the measures which were directed by GNCT judgment was that the time limit for acquisition by the government under the 2013 Act was prescribed to be 1 year. So it said that you now reacquire the land in 2013. Don't leave the land losers high and dry. They will not take compensation under the old act. Give them compensation under the new act. Status quo should be maintained. Until then, the land losers should not create any third-party rights, etc., or change the nature of the land by raising any construction. Then the court dispensed with certain chapters of the 2013 Rehabilitation Act, because in 2013 Act, like I said in the initial part of this lecture, before you acquire land, you have to do a lot of other exercise, the pre-acquisition exercise. There have to be surveys, there have to be rehabilitation, resettlement schemes, etc. So the court exempted the government from complying with all those provisions, because it said that already the matters have been pending in the court for these acquisitions for the last many years. And it directed the concerned collectors to assess the compensation as per the 2013 Act. And then it says that you may apply to the government for rehabilitation, resettlement, etc. after you get the compensation, but not as a precursor to acquisition of land. Now, I am a little surprised, and you may please make a note of two judgments. Actually, this GNCT versus BSK is a combination of three judgments, three different judgments given by the same honorable bench on the same day, one after the other, because in this dichotomy of Pune and Indore, several situations arose. So this was just one situation that one authority had come, SLP or civil appeal dismissed, the other authority had not come. It came later after Indore was pronounced. So this judgment took care of those situations. The other judgment, the second judgment, you may make a note, is DDA versus Tejpal, 2024 SCC online Supreme Court 1091, decided on the same day, 17th May 2024. Now, this judgment was given separately because the court had segregated cases in which there was inordinate delay in filing SLPs by the statutory authorities. Now, please try and understand, the Pune Municipal judgment came on 24 January 2014. Several cases were being decided thereafter. Indore came on 20th of March or someday in March of 2020. So in these 6 years, there were cases where the statutory authorities were satisfied with the High Court order, because they thought that why should we go when Pune holds the field? We will not get anything. They were advised not to file SLP. But then when Indore came, they were advised to file SLP. So naturally, there was a whole lot of delay in challenging High Court orders which were passed in, say, 2014, 15, etc. So the Honorable Supreme Court segregated those cases and discussed the aspect of delay, whether it can be condoned, not condoned, etc. in DDA versus Tejpal. Because it is not in your syllabus, I am not able to tell you in detail about this, but you must read. It's a simple read. You must read. I expect that if somebody asks you a question from BSK, they will also ask you a question from DDA versus Tejpal. They may also ask you in what categories did the court classify all these cases. And the third one was GNCT versus KL Rathi Steels. Now, this is 2024 SCC Online Supreme Court 1090. Here, the third aspect, and therefore it was classified and kept differently, was that there were matters in which SLPs were filed by the government authorities basis after the High Court had given judgment in favor of the landowners basis Pune. And then after Indore came, the authorities had filed review petitions. So this was a reference. This particular judgment was a reference. Earlier, there was a judgment by the same name by Justice Nagaratna and Justice Shah, Justice M.R. Shah, as his lordship then was. There was Justice Nagaratna had dissented. They had given different judgments. So it was referred to the three judges bench. And then the three judges bench has very eloquently discussed the aspects of review, maintainability of the review, and some benefit has been given to the landowners in that judgment, not entirely, but partially. So you may read this judgment also. Please read all of these three judgments together for a better understanding. All of them relate to the dichotomy period after Pune and the anomalies which started arising after the 2020 Constitution Bench was pronounced. So we are done with two judgments. Now I will go on to the third judgment, Property Owners Association versus State of Maharashtra, 2024, SEC Online, Supreme Court, 3122. Now it's a 9 judges constitution bench. The lecture for this is slightly lengthy, so just bear with it. It may take a little extra time than the first two judgments. Now this is a judgment concerning the property rights. It was given on 5th of November 2024 by 8:1 majority. The bench led by Honorable Justice Chief Justice D.Y. Chandrachud, as his lordship then was. Unanimously, this judgment holds that Article 31C of the Constitution, please keep the Constitution with you, because this 31C and 39 will be repeated in this lecture. If you read it, it will make you understand it better. And the final verdict was that 31C cannot be erased from the statute book, which is the Constitution, and it continues to exist. Now, the judgment of the court was authored by Chief Justice Honorable Justice Chandrachud for himself and 6 other judges. Justice Nagaratna authored a partially dissenting opinion, and Justice Sudhanshu Dhulia penned a complete dissent. Now, a very brief factual background to understand what was the controversy. The dispute in this case originally arose from Mumbai city. So the court traced the history of Mumbai. It was said that Mumbai is one of the most popular cities in India. It had a persistent problem of existence of a large number of old and common dilapidated buildings faced by its residents. Bombay was originally a group of 7 islands at the turn. So it's an interesting judgment. You'll get to know history of Bombay. I never knew. These islands were merged by a series of land reclamation projects to create what is known as the island city of Bombay. So the state of Maharashtra, now the controversy starts, enacted the Maharashtra Housing and Area Development Act. It's popularly known as MHADA in the Supreme Court corridors, to facilitate the construction or reconstruction of old and dangerous buildings and improve slum areas. So in the year 1986, the state of Maharashtra amended MHADA to include a chapter called Chapter 8A. So what is that Chapter 8A? Chapter 8A is, it allows for acquisition of redeveloped properties for erstwhile occupiers. There was a section 1A, which was also sought to be inserted in the MHADA, which states that MHADA gives effect to a state policy specified in clause B of Article 39 of the Constitution. Article 39B at its turn provides that the state shall ensure that ownership and control over material resources of the community. Now, please keep in mind this quote unquote expression, material resources of the community, which will serve us well throughout this lecture on this judgment, are distributed to serve the common. So, as expected, the validity of Chapter 8A of MHADA was challenged in the Honorable Bombay High Court. 13 December 91, the Honorable High Court held that Chapter 8A was saved by Article 31C of the Constitution, as it gave effect to the principles laid down in the DPCP, which is Article 39B, Directive Principles of State Policy. So Article 31C says that laws giving effect to the principles in Articles 39B and C cannot be struck down on the basis of violation of equality or right to freedom, Articles 14 and 19. So this judgment now reaches the Honorable Supreme Court in 1996. It is referred to a larger bench. In 2001, a constitution bench of 5 judges of the Supreme Court refers it to a 7 judges bench, because while hearing, it observes that the correctness of another judgment called Sanjeev Coke Manufacturing. It's popularly called as the Sanjeev Coke judgment, 1982 Supreme Court, which was a 7 judges bench decision. So it said that Sanjeev Coke needs to be reconsidered because Sanjeev Coke relies on a concurring but minority opinion by Justice Krishna Iyer in state of Karnataka versus Ranganath Reddy. So I hope we are not going round and round in circles, but this is what this judgment is. So you'll have to just understand it very, very carefully. 1977 state of Karnataka was state versus Ranganatha Reddy judgment, which was also regarding interpretation of material resources of the community. Now in 2002, the 7 judges bench had to refer this matter to a 9 judges bench, because now comes the 9 judge bench for consideration, which was the 96 judgment of Mafatlal Industries versus Union of India, as to what types of properties can be said to constitute material resources of the community under Article 39B. Now, coming back to the 9 judges judgment, which is relevant for today's discussion and for your exam, is property owners and just to take a small pause, this property owners, I'm very hopeful you will get one question at least from this judgment. It's a very important judgment for Indian jurisprudence and the constitution. So you must go through it very, very carefully. My endeavor is to give you a brief outlook so that you can understand it better upon your reading. So the Supreme Court had two issues to deliberate upon with respect to private property. One was whether Article 31C of the Constitution, which pertains to property rights, remains valid despite amendments and court rulings that have affected its scope. Rulings I have delineated in the earlier part, I'll just come to them in a little more detail. It was designed to protect laws aimed at ensuring the equitable distribution of resources for the common, Article 39B, and preventing the concentration of wealth, which is Article 39C. In response to judicial challenges to government policies like bank nationalization, etc., the 25th Amendment Act was introduced in 1971. 25th Amendment expanded Article 31C to protect the state laws implementing the principles of 39B and C of the Constitution, even if they were in conflict with the rights enshrined under Articles 14, 19, and 31. Now, going down the history, in 1976 comes the 42nd Amendment to the Constitution, which extended Article 31C to shield all directive principles, which is the Part 4 of the Constitution, from challenges. This extension was invalidated by the Minerva Mills judgment in 1980, which reaffirmed the protection for 39B and C. Now, this was the first question. Slightly lengthy question, I understand, but please go through it. The second question was as to interpretation of Article 39B. So the Supreme Court deliberated in the present judgment, today's judgment, also deliberated on the question whether the government can categorize privately owned property as material resources of the community and thereby acquire it for redistribution. So Article 39B mandates the state to promote equitable distribution of material resources of the community. So this was the long and short of the discussion, but it's a 500-page judgment. I have tried to cull out relevant features. Please have a thorough read of this judgment. It's an important judgment. Now, quickly, what was the evolution of the right to property? Because having heard the technical questions which were involved, let me now try and make it as simple as I can. So, right to property, we have to understand what has been the evolution. Initially, it was a fundamental right to property and compensation for acquisition. Articles were 19(1)(f) and 31. Then comes the 25th Amendment to the Constitution in 1971. Article 31C, which is relevant for today's discussion, does two things now in 71. The first part of Article 31C declares that laws advancing the DPSP, the directive principles in 39B and C of the Constitution, cannot be declared void for being inconsistent with Articles 14 and 19, which is the fundamental rights. The second part saved such laws from being challenged in the court if they failed to give effect to the principles enshrined under the two DPSPs, which is the 39B and C. Then comes Keshwananda Bharti in 1973, which is a 13-judge constitution bench. It struck down second part of 31C vis-a-vis the basic structure doctrine of the Constitution. And after this decision, the Parliament passed the 42nd Amendment in the year 1976. So Parliament passes the 42nd Amendment, of which Section 4 substitutes the words Clause B or Clause C of Article 39, quote unquote, with the words all or any of the principles laid down in Part 4. So in a sense, what it does is that it extended the scope of Article 31C to encompass all the directive principles of state policy. Article 31C was thus amended by the 42nd Amendment, and the phrase, like I told you, was replaced, which meant that if any law was made towards enforcement of any of the DPSPs, then the same shall not be assailable or unconstitutional on the ground of being violative of Articles 14 and 19. Then came two more judgments, Vaman Rao and Minerva Mills. So Vaman Rao, the Constitution bench dealt with arguments concerning the validity of Article 31C as it stood prior to the 42nd Amendment. And in Minerva Mills judgment, again, the Constitution bench decided the validity of the changes brought to Article 31C by the 42nd Amendment. In Minerva Mills, the Constitution bench of 5 judges, it struck down the 42nd Amendment that replaced Articles 39B and C with all or any of the principles laid down in Part 4. However, the majority opinion held that the 42nd Amendment had the effect of abrogating Articles 14 and 19 in regard to the vast category and expand of laws described under amended Article 31C. What was Vaman Rao? Now, in Vaman Rao judgment, the constitutionality of the Maharashtra Land Ceiling of Holdings Act 1961 was challenged, which was placed in the 9th schedule of the Constitution of India. The majority held that validity of 31C as it was upheld earlier in Keshwananda Bharti was existing and continued to survive. Now, the last step in the evolution of right to property was in 1978 when it just became a constitutional right and not a fundamental right. The article was Article 300 capital A. So government could acquire property. The only obligation of the government was to pay compensation to the land loser. Now, to understand this 9 judges, which we are discussing today, we have to understand what state of Karnataka versus Ranganatha Reddy, the 1977 judgment did. It was a 7 judges bench decision by 4:3 majority. It ruled that privately owned resources are not necessarily material resources of the community. No problem. But the problem arose where? The problem arose that Justice Krishna Iyer Saab, in his dissenting opinion, held that material resource of the community in Article 39B extended to all national wealth, public or private, capable of meeting material needs. Now, the issue in that judgment related to constitutional validity of the Karnataka Contract Carriages Acquisition Ordinance 1976. It provided for nationalization of contract carriages, which was initially struck down by the Karnataka High Court. So the High Court examined the nexus between Articles 39B and C and examined whether resultantly it was protected by Article 31C. The High Court held that there was no substantial nexus between the purpose of the acquisition and Articles 39B and C. The matter comes to the Supreme Court. Now, the majority set aside the High Court judgment, affirmed the constitutionality of the impugned act, holding it to be protected by 31(2) by referring to the basic structure judgment, which is the Keshwananda Bharti judgment. However, the majority view in Ranganatha Reddy categorically held that they should not be understood to be agreeing with separate minority judgment of Justice Krishna Iyer. Now, what did Justice Krishna Iyer do? He observed that all resources that satisfy material needs of the community, including privately owned resources, fall within the ambit of the phrase material resources of the community used under Article 39B and C, which meant that the state would have complete control on the private property also. So subsequently, even though the opinion of Justice Krishna Iyer was a separate one, not agreed to by the majority and being a minority opinion, however, it came into some kind of controversy later, which I will just explain because some judgments started following the minority judgment of Justice Krishna Iyer, particularly Sanjeev Kaur. Now we come to Sanjeev Kaur. This was a 5 judges constitution bench, unanimously adopted Justice Krishna Iyer's minority view in Ranga Reddy. So later in Mafatlal, which is a 1997 judgment, a 9 judges bench decision of the Supreme Court in a single line observation held that the material resources of the community are not confined to public resources, but include all resources, natural and man-made, public and privately. So I hope I am able to make it clear. The minority judgment of Justice Krishna Iyer adopted as the majority judgment in Sanjeev Coke Manufacturing and later on by Mafatlal Industries. So in Sanjeev Coke, challenge was made to the legislation which nationalized coke oven plants while leaving many others on the ground of violation of Article 14. So the Honorable Supreme Court repelled the challenge. It was a Coking Coal Mines Nationalization Act, 1970. And it was held that this act is not in violation of Article 14. And in doing so, the Sanjeev Coke judgment of the Honorable Supreme Court relies on the minority judgment of Justice Krishna Iyer in Ranganatha Reddy, that all material resources, even if they are privately owned, can be controlled by the government. So in effect, all the line of these judgments followed the minority view of Justice Krishna Iyer, and the following principles came to be laid down. Now you don't have to worry. This 9 judgment, the 9 bench judgment has now corrected the course. So, but what did the earlier judgments do by relying upon the minority judgment? It said that the purpose behind 39B and C is to allow the state to carry out a restructuring of the economy. Then the material resources of the community, they are things capable of producing wealth for the community, and therefore they have to include all resources, whether private or public. Then it also said that the nationalization of privately owned resources may give effect to 39B and C. The decisions which advance the above precepts uh, say that their interpretation is based on the fact that Article 39B and C are the DPSP of the Constitution, Chapter 4, and thus they have to be carried forward. Now, the validity of all these decisions, Justice Krishna Iyer's minority view, which remained a minority view, of course, and then Ranganatha Reddy and Sanjeev Koch Minerva Mills comes to be contested in today's judgment, which is Property Owners Association. So the majority opinion, authored by Chief Justice Dr. Chandrachud Saab, held that Justice Iyer in Ranganath Reddy ventured into the contours of 39B when the majority had stayed away from it. So in Justice Iyer's judgment, issues on interpretation of Article 39B and particularly the purport of the terms distribution and material resources were not even framed as issues by the majority, much less answered. So what he meant was that Justice Iyer should not have ventured into that field, and his opinion was incorrect because it cast a very wide net, holding that all resources which meet material needs have to be covered by the phrase. So further, Justice Chandrachud, speaking for the bench, the majority judgment in today's judgment, held that Justice Iyer was also wrong to hold that not just means of production, but also goods so produced fell within the net of provision. Now, the 9 judges bench has now held, by way of bullet points, that a material resource of the community has to be of the following nature. 1, it must be a resource. 2, it must be a material resource. 3, it must be of the community. Simple. So holding that all private property within the net of material resources of the community would satisfy only the first requirement. That is, it will only be a resource. The words of the community has to be in contradistinction with the word individual. So therefore, the majority now holds in the present judgment that Justice Iyer's opinion amounted to endorsing a particular economic policy for the country. It was contrary to the vision of the constitution framers who envisioned economic democracy but did not want to lay down a particular form of social structure or economic policy for future governments. So in this slide, the 7 judges have concluded that Justice Iyer's opinion was a doctrinal error and was a rigid economic theory not to be followed. Privately owned property could be a material resource, but not all private property was a material resource. So by 7:2 majority, it was held that not all private property constitutes material resources for 39B and C. Sanjeev Koch was thus overruled, and Justice Iyer's opinion anyway was minority opinion of that judgment of Ranganatha Reddy. So after Sanjeev Koch was overruled, all the honorable judges have concurred that the single line observation made in Mafatlal was an arbiter. So there was no need to overrule Mafatlal, but it was observed as a fact that that one line observation, which seems to be in line with Justice Iyer's judgment in Mafatlal, was an arbiter and cannot be treated as a ratio of the Mafatlal judgment, which was also a 9 judges judgment. Now, the constitutionality of MADA, of course, in which fact situation this judgment arose, after holding all of this, the majority left it for the regular bench to be decided. As and when it comes up, it will be decided on the said principles. Now, there is one very important issue which this judgment has brought to light, and therefore you must read it. Again, it's a bit complex and technical, which is invalidation of an amendment revives the unamended text. Now, it arose how in this judgment? It arises like this. The court's decision in Minerva Mills restored the balance between fundamental rights and DPSPs, but it raised a critical question, which was that whether the unamended Article 31C automatically revive after the amendment was struck down. So this question remains unresolved until this present judgment in property owners, which now has decisively confirmed that the unamended Article 31C does indeed survive. And going by the emphasis in this syllabus on this judgment, I feel that this is one part of this judgment which you must read very carefully. They can ask you, what is the doctrine of revival? Now, the interpretation of Article 31C was disputed. If you would recall what I have narrated in the earlier part of the lecture, because amendment to Article 31C had been struck down and a question had arisen as to whether the text as it stood before the amendment continues to have effect. So the Supreme Court holds that when an amendment is struck down, the original unamended text is revived unless there was clear legislative intent to repeal the amended provision independently. So retaining of the unamended text, the court holds now in this judgment, was essential to maintain the constitutional stability. When amending Article 31C, court says that the legislature only intended to modify and not to repeal the article. So once the modification is struck down, we go back to the original article. The court also observed that the unamended text of 31C had itself been challenged and upheld in Keshwananda, the basic structure, in 1973. So thus, after the amendment to 31C was struck down in Minerva Mills, the unamended 31C stood revived. Article 31C thus continues to protect legislation, giving effect to the principles of 39 BNC, the DPSP. So the court grounded its reasoning on the basic structure doctrine. The revival of original text, friends, ensures that invalidated amendments do not weaken the foundational and core values of the Constitution. It ensures continuity and coherence in fundamental rights and directive principles. The court also explained the two expressions, the original text and the amended text. The court observed that if the amended text is invalidated, the only valid expression of legislative intent is the original text. The court emphasized that if it were to assume that the original text could not be enforced because it had been repealed, this would also lead to a third outcome, which is a legal vacuum which shall be created, which was not intended as a possible outcome. Now, there were two more judgments in this in this judgment of property owners. Before I come to that, I just want to sum up what the majority has held. Now, since it's a lengthy judgment, I have tried my level best to just try and outline how best I can make you explain. So therefore, we've just summarized this. What has the majority now held? The majority has held that Article 31C, to the extent it was upheld in Keshwanand Bharti, remains in force. That is the first proposition. Sanjeev Kok goes out of the stadium. Overruled. Single sentence observation in Mafatlal about material resources of community being inclusive of privately owned resources is not part of the ratio. It's obiter dictum of the 9 judges bench in Mafatlal. The question as regards material resources of the community used in Article 39 BNC includes privately owned resources, but not every resource owned by an individual can be considered as a material resource of the community merely because it meets the qualifier of material needs. The inquiry as to whether the resource falls within the ambit of 39 BNC or it is immune from the control of the state has to be context specific in every case and not as a matter of rule either ways. So subject to a non-exhaustive list of factors enumerated in the judgment. The public trust doctrine, it says, will also help identify resources which fall within the ambit of the phrase material resource of the community. Now the court then goes on to hold that there has to be a flexible approach of interpretation significantly, where there is evidence to suggest that legislature would have repealed the original text independent of introducing the amended text. A court can continue to give effect to the repeal despite invalidating the new text. So this revival doctrine, you must, I am saying at the cost of reiteration, you must go through very carefully in this 9 judges bench decision, apart from the merits of the judgment itself. The court has also laid down some broader principles on how smaller benches should agree or disagree with the larger benches and what is the course ahead. Because the anomaly arose because of Justice Krishna Iyer's minority judgment. So the court has given several rules of judicial discipline and how the decorum is to be maintained in the Supreme Court in terms of referring the matters to larger benches. Some of it was part of my Sunday lecture also. So therefore, I'm not going to repeat it. But if you read this judgment, you will find that it lays down several principles. There can be a question from this judgment, based on this judgment, but saying that given the fact that Justice Iyer's judgment gave rise to so many anomalies, how would you suggest is the judicial discipline and judicial decorum to be maintained as per this judgment? So you must call out these 5-6 principles which are given in this judgment. Now coming back to two minority judgments very quickly, I'll just take 2-3 minutes on both of them. One was Justice Nagaratna. She authored a separate partly dissenting opinion, not completely dissenting. She gave a partly dissenting judgment holding that all privately owned resources except for personal effects can constitute material resources of the community. So she only gave one exception, which was personal effects, and private property can be transformed into community resources through nationalization or acquisition. There cannot be any dispute to that, of course. So Justice Nagaratna disagrees with the reasoning of the majority that Justice Iyer's opinion does a disservice to the broad and flexible spirit of the Constitution. So she says that the opinion of the majority, authored by Dr. Chandrachud, on Justice Iyer's judgment, in fact, she calls it unwarranted and unjustified. She notes that his opinion came in the backdrop of a constitutional, Justice Iyer's opinion came in the backdrop of a constitutional, economic, and social culture that gave primacy to the state over the individual. She also notes that it is a matter of concern that the judicial brethren of posterity viewed the judgments of the brethren of the past, possibly by losing sight of the times in which the latter discharged their duties and the socio-economic policies were pursued by the state and formed part of the constitutional culture during those times. So slightly critical of the chief's judgment, Justice Nagaratna also expresses caution. She says that all those opinions were rendered in those black and white times as per the prevailing socio-economic norms, and a paradigm shift in the now economic policy of our country should not result in branding the opinions of past judges as having done a disservice to the Constitution. So Justice Nagaratna has observed that all privately owned material resources should be first converted into material resources of the community, and only then can they be distributed to serve the common good, except personal belongings, which is personal effects, like I said. And of course, the land loser or the property user should be compensated. In his dissenting opinion, the second dissenting opinion is a stronger dissent by Justice Sudhanshu Dhulia. He also expressed a strong disagreement with the chief's conclusions on Justice Iyer's opinion. He concluded that Justice Iyer's opinion was based on strong humanist principles of fairness and equity. So he endorsed Justice Iyer's view that all private property is a material resource of the community. It was difficult to even accept, says Justice Dhulia, that the majority of 4 judges in Ranganatha Reddy entirely disagreed with Justice Iyer's minority opinion. So what does Justice Dhulia say? He says that when the majority of judges in Ranganatha Reddy held that they must not be misunderstood to agree with the minority judgment of Justice Iyer, it was not exact disagreement, rather they simply chose to remain silent on the issue. Now, this is also interesting, but again leading to a legal riddle. When the majority view was silent on some aspects, the minority view would have persuasive value, is the way Justice Dhulia has looked at the minority opinion of Justice Krishna. However, Justice Dhulia in his dissent goes on to hold that as per the majority in Ranganath Reddy, since it was silent on the issue and the concurring opinion in Reddy had reached the same conclusion as the majority by a different reasoning, though the concurring opinion in Ranganatha Reddy could be followed. Now, Justice Dhulia finally in his dissent observes that the phrase material resources of the community must be given an expansive meaning. It is the task of the legislature to decide what and when privately owned resources that serve the common good form part of the material resources of the community. The social inequalities that existed at the time of commencement of the Constitution still exist, and therefore the principles laid down in Articles 38 and 39 cannot be abandoned. So the judgment states that if privately owned resources, Justice Dhulia's judgment, I mean, are not a part of material resources of the community, then only public resources are included, and they are in any case meant to serve the public. So now, where does it lead to? So it leads to this, that essentially the 9 judges judgment of the court has now held that the position post Keshwananda Bharti remains valid. Article 31C is preserved for Articles 39 B and C. The government's authority is limited by rejecting the broad interpretation endorsed by Justice Iyer's minority judgment. The court rules that not all privately owned property can be deemed material resources of the community. Factors like public trust, doctrine, resources, intrinsic qualities, community impact, scarcity, etc., are to be considered. It narrows down the government scope to acquire private property, so all of us can be a little happy. Under Article 39B, it emphasizes individual property rights and clarifies the limits on government power. It says that the court's role is not to prescribe economic policy, but to support an economic democracy as envisioned by the Constitution. The directive principles of state policy are guiding policies and not enforceable laws. That, of course, is the age-old law which has been laid down. So this judgment, friends, has now affirmed the people's role in shaping India's economic direction. It offers protection for marginalized communities against unjust acquisition of their small farms, etc. It reinforces that India now follows a market-oriented economic model and that right to property is now constitutionally protected under 300A, which is not only a constitutional right, but please mark, they have said that it is also a human right, so to say. Now, I must give credit for my lecture to 2 blogs, and you can also go through them to understand this judgment even better if you have time. So you may make a note of this. This is 2025 SCC Online Blog Expert 22 and 2024 SCC Online Blog Expert 83. 22 is authored by Siddharth Gupta and Khushi Dwivedi, and 83 is authored by Mr. Varun Pathak and Mr. Tejpal Singh Rathod. So my credit must be due to them. Their blogs have helped me in preparing this lecture. Over to you, SCAORA.
Thank you so much, sir, for such an insightful session. And you've not just covered these 3 leading cases, but at the same time, very beautifully, you've touched upon all the aspects of right to property as well in a very, very detailed manner. And I'm sure that the aspirants are going to be deeply benefited by that. Won't take much time here. Handing over to my colleague, Dr. Meenakshi Kalra, from here on. Thank you so much.
Thank you, Pragya. So, sir, there are 3 main questions that have been asked. The first question is by SRV. He's asked that the state need not deposit money to landowners. Enough if the tender compensation is sufficient. Kindly advise on this statement if this is correct. And how about the interest in section 34? Please advise.
Now, see, the old act stands repealed. That is one. So what we have to see is that for lapse, did the state, so that is something which is history. Now this will not happen because the new act has come. So in the old acquisitions, if the state had tendered the compensation to the landowner, what used to happen was landowners were always advised, don't take compensation if you want to challenge the notification and the acquisition. So they would not take. So now Indore development says that if they have not taken and the collector or the government keeps it with him in the treasury belongs to the government, not to the court. Even that tender is enough. It will be treated as compensation paid for the purpose of 24(2) and benefit goes to the government, not to the landowner. Yes.
Sir, and the other question asked is by Rajesh Kumar that in the Indore judgment, is land acquisition valid even if the compensation is deposited in the court or treasury and not actually paid to the landowners later?
So I think it was a similar question which I have just answered. So the court says that compensation need not be actually paid or deposited in the court because the government cannot be at the mercy of the landowners. So what the procedure used to be under the 1894 Act, the government would issue them notice. Government would tell them your compensation is ready, come and take it. So if they would give their account details, the government was to deposit. If nobody used to come forward, Pune Municipal said obligation was to deposit with the district judge who can make a fixed deposit, etc., to earn interest. But Indore says that government can keep it in their pocket. The only liability would be interest, 9% for the first default year and 15% for the second default. It will not lead to lapsing of the land. So they will not get back their land.
Right,
Ji.
sir. The third question is by Abhimanyu Yadav. He's asked
Hmm.
that does Indore or BSK have any reference to property owner association? If yes, what are the specifics?
No, Indore and BSK are completely different. Property owners is completely different. Property owners is Article 31C vis-a-vis the directive principles of state policy, Article 39 BNC. Indore and BSK are completely different. So Indore, BSK, Tejpal and KL Rathi.
Separate.
The
Right.
four of them form a set, and property owners is a completely
That's
different
different.
context. Completely
Yes.
different context.
Yes. The
Thank
last question is by Mr. Rajesh Kumar. He says that did Sanjeev Coke overrule Ranganathan?
No. Sanjeev Coke did not overrule Ranganathan. It rather relied on the minority view of Justice Krishna Iyer and said something which was not acceptable. So therefore, Sanjeev Coke is now overruled by property owners.
And the last question by SCAORA is, will you be able to share the notes for today's lecture?
Yes, why not? They're all meant for my SCAORA friends and all the people who are going to become advocates on record. It's not for myself. There's no copyright. I will immediately share.
Thank you, sir. Meenakshi ma'am can now do the vote of thanks now that the questionnaire is over.
I, behalf of the Supreme Court Advocate on Record Association Executive Committee, sir, I extend our heartfelt gratitude to you for being an esteemed part of the SCAORA AOR Lectures 2025. This is your second lecture here, and your illuminating insights on all the three judgments and related important judgments have been invaluable. Your expertise in highlighting the important paragraphs and crucial topics for the exam will undoubtedly benefit the AOR aspirants. Notably, as a second position rank holder in AOR examination, your in-depth knowledge lends significant credibility to your guidance, providing aspirants with a first-hand understanding of what it takes to excel. Your thoughtful analysis has provided a clarity on important questions, giving aspirants a significant edge. We appreciate your gracious presence, sir, and we look forward to having you again on board for the future AOR lecture series. Thank you for everybody who's watched this lecture in large numbers. I, on behalf of SCAORA, wish everyone the very best of luck for the upcoming AOR exams.
Thank you. My wishes to all of you and the aspirants.
Thank you, sir. Thank you very much, sir.
Have a great vacation. Bye.
Thank you, sir.
Thank you, sir.